Going to have a short 5-minute-ish introductory comments from our 4 speakers who are listed in the panel. It will be Drew, and then Suzanne, and then Greg, and then Gail. And then I'll have some questions, and you'll have a chance for questions. But the focus here is on some of the short-term issues that we're facing, including the US-UK agreement. So Drew, take it away.
Sure. Yeah. So thanks so much, Peter. I actually grew up in a household with allegiance to another ACC technical school. But it's been a pleasure to visit. Virginia Tech is the other one. But it's been a pleasure to visit you guys. It's been really great. Thanks for having us. So I'll start just by introducing kind of what the US-UK agreement is, and then share the organization that I work for's perspective on it a little bit, and then I think we'll have a little conversation about it going forward. But I work for an organization called Access Now, which is a digital rights organization. So we focus on things like privacy and freedom of expression. I work in the DC office, and so, but we have offices all over the globe. So kind of the perspective that we try to bring to the conversation is thinking about the effects of policies like the ones we're discussing today on international users. So not just thinking domestic, but thinking kind of the full scope of effect. So the US-UK agreement. So I guess to start, just kind of thinking about the status quo, the way the system currently works for requesting data across borders is we use the Mutual Legal Assistance Treaty process, which I know has come up already today, but it's a process by which we use bilateral and multilateral treaties. We request data through the other country that we have the treaty with, and then it's kind of it goes through their legal system as well, and then if it satisfies the standard, then it goes back to the country making the request. And so what the US-UK agreement would do is it would essentially serve as a safe harbor to bypass that check, where the receiving country would serve kind of as an oversight body. It would instead enable countries to go, the UK in this instance, to go directly to a company and request data, even if it's stored across the border. So the agreement so far we haven't actually seen the text of it, at least publicly, but it's materialized through implementing legislation on the U.S. side. Last year, we saw a draft legislation that would have passed. It would have amended ECPA, which is privacy law on the U.S. side, that would have enabled companies to transfer electronic communications without violating the law. So they could have transferred the data to foreign governments. So the question for us as a human rights focused organization is this an agreement that is going to serve as a net positive for human rights and address kind of many of the threats that we looked at today? And I know we talked a lot about localization. Dylan just did that great presentation, but there are a lot of issues that have been brought up in the context of the kinds of challenges of MLATs, which are things like encryption mandates and arresting executives and just extending jurisdiction kind of beyond borders and all this kind of stuff. So I think there are a couple points, which are, first of all, I would suggest that by removing the MLAT protections, it's important to note that we're losing some of the privacy protections. And so any system that serves as a bypass around the MLAT system has to contain the appropriate human rights protections to ensure that we're not just sacrificing human rights at the expense of ensuring law enforcement has access. And then the other point I would make generally, before I get into a few more specifics, is that the US-UK agreement would not serve as an ultimate solution, in that it wouldn't stop China and Russia from implementing localization requirements. It wouldn't stop many of the harmful internet-focused policies that we've seen implemented over the past couple of years. So while it might have some benefit on the countries that would be able to participate, it wouldn't necessarily have the same positive effects across the whole internet ecosystem. And so recognizing that the effects of such an arrangement would be somewhat narrow. So just to go into a couple points, the human rights language with agreement was fairly narrow. We would say it was inadequate to protect human rights. So the way it operates, as proposed, is that the U.S. Department of Justice, with its consultation with the Department of State, would be able to certify a country for participation in the program, and then that country would be able to create an agreement with the United States that would enable this transfer. So initially it would have been the UK before eventually opening it up to other countries. But the language in the legislation itself was fairly broad. So it was only that the country had to demonstrate respect for international human rights was the only requirement. And so, I think that was probably put in there, recognizing that a lot of the countries that would want to participate and that the U.S. might have an interest in seeing participate wouldn't meet something more substantial than just saying let's demonstrate respect, which is a fairly low standard. And you can kind of see how this would play out in practice in the UK context, because the UK Investigatory Powers Act doesn't require a judicially approved warrant for a live intercept, and nonetheless, it does. Well, is it fair to say that at least the judicial commissioner might not be the standard that we would expect in the U.S. at least?
It's certainly not probable cause.
So it doesn't satisfy at least maybe the U.S. standard we would say for intercept. So you can see in that instance how it wouldn't, there could be a sacrifice, made. Another point is that in the way it has been implemented so far in the implementing legislation or proposed is that there were much more broad protections for U.S. persons than for other persons internationally. So it contained specific protections for U.S. persons, and it also contained a power for the U.S. to veto requests. But as you can imagine, it would likely play out that the U.S. would use that authority specifically to veto requests that had some effect on U.S. persons, but not so much if, for example, the requesting country made a request for a person of a third party country. And so I think it's likely you would see kind of an arrangement where the U.S. and maybe the partner countries would be afforded greater protections than for other people. The way that the process actually works where the Department of Justice, with the consultation of the Department of State, makes the decision as to who actually gets to participate, I think it's fair to say it would be a political system that we wouldn't see kind of an open process where anyone that met that standard were able to participate. And so there's no kind of independent evaluation for making that decision. And then finally, I would just say that, as I mentioned earlier, we have to recognize that this wouldn't be an ultimate solution to many of the problems we talked about today. And what's missing from the proposal is any attempt to also shore up the MLAT system, which we would still depend on quite heavily, I would say, for those countries that haven't reached an arrangement with the United States, right? So one of the things the Obama administration said as a priority for thinking about MLATs is assisting countries meet the standard that they would have to satisfy in making requests to the U.S. And we have I think there's a lot more opportunity to take those kind of steps to shore up the MLAT system. So the U.S.-UK agreement would miss a big chunk of the countries that would participate and also kind of fail to satisfy a large part of the problem that we're talking
about. So yeah, I'm going to follow up with what Drew just said. And so we all know here that the EU and the US have very different data protection laws. And so from there, we started thinking, okay, if there are differences in the data protection sector, what are the differences that exist in the criminal procedure laws? And as Bruno Giancarelli said this morning, there is not a normalized law on this particular topic, on the way French criminal investigating authorities are getting evidence in member states. It's a matter of sovereignty, so it's a matter of member state law, and then we have agreements in the EU to help investigating authorities work together. But we don't have a normalized law, so we need to look at the member states law to know how an investigating authority needs, what are the standards an investigating authority needs to meet in order to have access to evidence. And so with that, with Peter and Justin, we thought that to have a better, at least a more informed reform of the MLAT system, we needed to understand what were the standards to, like, for investigating authorities to meet to gain access to evidence in France and in the US. So we wrote an article and we discussed these different standards. I'm not going to go over the US standards because here I think it's a big majority of a US audience, so you know that better than me, so I'm not going to go over that. But what I'm going to say is that the US has created a multi-tiered set of standards under the ECPA and the SCA with different rules for basic subscriber information, metadata, content, and intersection of electronic communications. So thus, the US system relies more heavily on distance rule for different categories of electronic evidence. In contrast, France has a tradition of relying on the acts that can be performed at each stage of the investigation, as well as the investigating authority of a particular actor, such as a magistrate or a prosecutor or the liberty and custody judge or officer of the judicial police. So that once we said that, okay, then we have to go deep further and we have to look at what are the different standards. So I'm not going to go over the US standards, but for the French system, we just said that there is a tradition on relying on the acts that can be performed at each stage of the investigation. So, for instance, for the search and seizure regime, different rules applies to different types of investigation. When we are in fragmented delicto investigation, the search is permitted if the nature of the crime is such that the proof can be obtained by the seizure of the information, and if the person whose home is searched is present. Then, for preliminary information investigation, the French Code of Criminal Procedure requires the officer of the judicial police to obtain the written consent of the person whose home is to be searched. Then, for formal investigation, the French Code of Criminal Procedure provides broad powers to the investigating magistrates because it allows her to order the search of any place where one can discover objects or data. So to be legal, the search only needs to be necessary to establish the truth of an offense. So it's very different from the US system. Then when we look at the standards for the interception of communications by means of telecommunications, it's regulated with very specific circumstances. So interception can be ordered in cases involving criminal offenses and misdemeanors sanctioned by imprisonment of at least 2 years, and when the circumstances of the case require interception. And there was a recent law that was passed in July 2016 that modified this regime to allow the civil, the liberties and custody judge and the investigating magistrates to issue ordinance. It's called ordonnance motivée, which is a writ. And so they can, when it's necessary for the investigation, they can have remote access to the stock of emails without the user's consent. So you see it's a very lower standard, but we have different actors who can ask to have access to the evidence. Then for the real-time interception of data, again, the regime was amended last year in July, and under the new regime, the liberties and custody judge and the investigating magistrates can have a decision to intercept in real time data, and that decision needs to indicate the specific offense, why they're asking to have access to the real-time data, the localization of the description of the information of the system to be accessed, and the duration of the read. So it's very lower from what is the standard in the US. So we see that French system relies more on the people asking to get access to the evidence than the standard of that you have to meet when you want to have access to the evidence. And so my other point is that we saw recent reforms in France. We saw the last year criminal law that was passed that is lowering the standards to be shown to get access to evidence. And so we have a question to ask ourselves when we negotiate bilateral or multilateral treaties, which is what is going to be the long-term review of the agreement. Because one day it can be okay, and then with two different laws, the standards and the equilibrium between security and liberty is different, and it might not meet the same standards. And so we have to ask ourselves what is the long-term view of these agreements. And to develop this idea, I want to discuss a bit about the state of emergency regime that we have in France that has been prorogated 5 times since November 2015. So the state of emergency in France, I'll give you just the big principles. Yeah. Thank you. So mainly the state of emergency provides extensive broad powers to the Minister of Interior and the prefects of regions. And basically, they have many powers. For instance, they can restrict freedom of movement in the territory in many ways. They can dissolve associations. They can also gain limited control to the press. So it's a very different regime than the one we had before the state of emergency. And I wanted to talk a bit about the collection of and access to evidence under the state of emergency regime. Because first, the French Constitutional Council considered twice that the regime that was provided in the law was not constitutional. So twice they said, no, the equilibrium is not okay, and it's too invasive. We don't know what you're going to do with the data. Once you had them, once you seized them, there was no oversight, no judicial oversight. There was nothing, just a Minister of Interior getting the data, and no one really knew what was going on with the data afterwards. So this was a big thing, and activists in France were really worried because of the very broad search and seizure regime that was that is provided still until July 2017 at least. And so yes, this search and seizure regime is very has much less safeguards than the criminal procedure traditional law. So that was my two different things. When you think about an agreement, you think you need to actually get into the subject, get into the laws that exist, how they're implemented, and what are the safeguards existing into a system. And then when you think about an agreement, it might be okay in one day, but you have to think in the long term and what are the reviews that you have to have in place to make sure that the regime is still safe 5 years after.
So Suzanne, you wrote about this, right? At least before the emergency legislation. Where can people find that writing?
Okay, so you have 2 articles on SSRN, and one was published in a book, and another one is published in the Wisconsin International Law Journal.
And one resource is we have a page for all our research at Georgia Tech that's up on the website for Georgia Tech.
I'm Greg Nojine with the Center for Democracy and Technology, and our stuff is available on our website, www.cdt.org. If you want stuff about this issue, Google my last, don't Google that. Put my last name into your search engine. It is Nojeim. It's kind of unique, and with MLAT, and you'll get our stuff. Now, when I look at the US-UK agreement, well, I don't look at the agreement because that's not public. I look at the legislation that the Department of Justice proposed, DOJ's description of the legislation, and then the legislation that the UK adopted, very brief legislation, part of the IP bill. And that's all we really have in order to analyze this issue. And when I think about these things, I think about what are the different interests that this legislation or this approach needs to address. And a hat tip to Peter and his colleagues for coming up with some of this and writing about it. So the interests are the human rights of users have to be protected, as Drew mentioned at the outset. Obviously, law enforcement access to data to solve crimes, that needs to be promoted. There needs to be clarity, certainty, and dependability, and scalability in any solution. That serves, I think, all the players in the ecosystem. There needs to be comity. The idea that one country won't reach into another country with some degree of, usually in international law, it's force to accomplish something. The interest of the country to control intrusive conduct within its borders. And to my mind, also reciprocity. That if there's going to be a regime that works for one country, it ought to work for the other country that's a party to the agreement, and then it ought to be scalable up to other countries that might enter into agreements. So measured against those goals, I look at the bilateral agreement proposed between the US and the UK as a possible partial solution to the cross-border, to the problem of cross-border demands. As Drew pointed out, obviously it's not going to be complete because it won't deal with the problems that other countries that don't have these agreements will have. On the other hand, and just to add to that a little bit, Russia and China and other countries that might not be beneficiaries of such an agreement, they have crimes that they need to solve, and they have a legitimate need for data that is held by U.S. tech companies. So we do have to have in mind solutions to those problems as well. Probably not a bilateral agreement, but maybe a beefed up MLAT system, a more resourced MLAT system. That said, that these bilateral agreements might be part of the solution to this problem. In the particular U.S. legislation that was proposed for this one, we see some needed, necessary improvements, and they are not insignificant. They are significant improvements that we would be calling for. First, the U.S. legislation contemplates that there would not just be a fix to the MLAT problem, which is access to stored data, but there would be a new opportunity for surveillance, the access to real-time information by the UK and other governments that reach these agreements, which under current law is a crime. It is a crime for a foreign government to conduct wiretapping in the United States. The agreement would make it possible for that wiretapping to occur. Second, the standards in the legislation are, as Drew mentioned, quite weak. In addition to the point Drew made, there are 5 factors that the Department of Justice and the Department of State must consider before deciding whether to enter into an agreement with another country. One of those factors is that that country can't engage in torture. Well, that shouldn't be just a factor. It seems like that should be a requirement. You don't want to send data over to a country that might use that data to torture a person. So there needs to be some strengthening of the criteria for entering into one of these agreements. There needs to be a credible mechanism for determining whether the country with which the U.S. might enter into such an agreement has met the standards that the legislation has set. Right now, there is no credible mechanism. It's just the Department of Justice consulting with the Department of State. And the decision will probably be based on information that's not public and that could be influenced by political factors, such as, for example, whether the United States needs to use an air base in the eastern part of the country in order to send bombers into the Middle East, as one example. There is also an inadequate mechanism for the initial authorization in the legislation. And I think this is really one of the key factors, because when you think about MLATs, it's all about getting access to information. It's the front end where I think the human rights control needs to be strongest. The legislation doesn't require a strong factual basis and specific judicial authorization for the demands that the country would make. Instead, it talks about judicial supervision. Well, in DOJ parlance, the judiciary supervises Section 702 surveillance simply by approving minimization and targeting guidelines. Another thing that's missing from the legislation, it doesn't specify what standard the U.S. Would have to meet when it is going to British Telecom or to another provider in the UK in order to get information. And there's no provision in U.S. law that talks about a court having jurisdiction to issue an order to British Telecom or to another foreign provider to turn over data. So that whole reciprocity part of the legislation just isn't there. And finally, it doesn't deal with the metadata problem. The metadata problem in a nutshell is this. When the United States government wants traffic data of anybody in the United States or of anybody who is using a U.S. provider, the U.S. government has to get a court order to do it. Under U.S. law, the providers can volunteer that traffic data to a requesting foreign government. It actually puts foreign governments in a better position in terms of getting traffic data than the U.S. government is in, which seems to me kind of strange, and we want the leveling out to be at a higher standard. So, in conclusion, I'd leave you with this thought: that these bilateral agreements, they can be in advance. They are a possible partial solution, but a significant amount of work needs to be done to improve this. Thank you.
Gail.
So I'm Gail Kent, and I look at surveillance, cybersecurity, and law enforcement policy for Facebook. But before I joined Facebook, and I'm going to tell you why I joined Facebook in a second, I did 15 years in UK law enforcement, looking at organised crime and cybercrime, and then went to Stanford the day before the Snowden revelations broke to look at this literal studied thing called the MLAT problem, because it was a huge issue for UK law enforcement trying to investigate any sort of crime at the time. And then 2 years ago, or just under 2 years ago, I joined Facebook. And I joined for 3 reasons. Firstly, it's an amazing opportunity to work for Sheryl Sandberg, and who wouldn't want to do that? Secondly, I absolutely felt that my values aligned with the company's values about being open and connected. But thirdly, and perhaps most importantly for this audience, was I think this issue is one of the biggest challenges of our time. We're working in an environment where technology offers the ability to communicate in a far greater or more complex way than it ever has before. So if I think of the biggest issue that I had to deal with when I started my law enforcement career, looking at drugs traffickers, was what was the pattern of telephone kiosks that they were trying to work on? Or are they going to Smith and Jones, Corner Smith and Jones, or were they going to Main Street? Now you've got to try and work out what are the different ways that people are communicating, and the huge number of different data sets and types of data you've got. And Peter talked about the global age of surveillance, and undoubtedly companies like Facebook and Google are adding to the amount of data that we have in the world. And secondly, you've got this whole new international element to what has traditionally been a domestic problem. So 87% of our users are outside of the US. Our user base is not in the US. And to enable communities around the world to talk to each other. But that also means that law enforcement are interested in that data, because those communities, a tiny percentage of them, will be doing things that law enforcement would like to know know more about. What that means is that you're adding this whole foreign policy overlay to what has traditionally been a domestic problem. So at the crux of this issue, we've talked a little bit about the UK-US agreement. We have the fact that US domestic legislation correctly, as Greg has pointed out, makes it a crime for companies like Facebook to hand over data where US legal process hasn't been applied. And that is not just the US that does that, that is mirrored in most countries around the world. But just as you have that, you have law enforcement around the world trying to investigate, most of the time, local crimes. The reason I'm giving you a bit about my background is because I think it's important to understand that I've looked at this both as a pragmatist and also a theorist. And those are 2 points that I want to touch upon before I get to where I think the US and UK agreement helps us land. And the first point in terms of theory, Facebook, Google, at the moment we are both seen as a constrainer of surveillance and as we've talked about the golden age of surveillance, as people that enable it. This is a huge problem. And we need to get to the point that we can solve this. But that, for us, on a theoretical basis, is not companies that should be trying to solve that. It should be governments, and it should be us as stakeholders who are trying to feed into that. Which is why I hugely appreciate the work that a lot of people have done in this room, and particularly in academia, trying to look at how do you take into account all the different and important factors that Greg has outlined in coming up with what the perfect type of solution looks like. And I think there's a second theoretical issue that we have touched upon in various panels, and that is this is really complicated. So how do we get policymakers, no matter where they are in the world, to understand the complexities of this issue and to come up with solutions that meet all of those different requirements? And then if I'm looking at it pragmatically, then I think again comes back to it feels like on my day-to-day basis I am dealing with policy teams around the world who are being put under pressure from the governments that they're working with to asking questions: why can't Facebook provide more data? Why can't you provide this content? If I look at the countries that I've dealt with in the last week alone, Uganda, Switzerland, India, Brazil, Russia, this is not just a theoretical issue for us. This is one in which we are getting asked about and having court orders placed upon us every day. And I've not even got to the point of what it looks like in the press. I'm going to mention WhatsApp. It's another Facebook company, but WhatsApp, for me, in the last couple of weeks is a classic example of how we cannot win. So you'll have been aware that the UK Home Secretary, 2 days after the attack in Westminster, said that criticised WhatsApp for not providing enough information. That was last week. You can Google it or use your search engine and see that this is criticism that we get on a pretty much weekly basis. At the same time, if you look at EFF's last report on who's got your bag, you'll notice that WhatsApp doesn't get any stars whatsoever. So WhatsApp's been criticised for not doing enough to protect data, but equally being not doing enough, being criticised by governments for not providing enough to try and tackle the problems of national security and safety that governments are trying to deal with. And I think you also need to look at it from not just the technical and legal issue with what governments are looking at, you also see politics get thrown in there. And I don't think there will be a day goes by when I don't mention Brexit, but you can imagine what it's like if you are the European Union and you are seeing a UK-US agreement being discussed, and you're thinking, well, wait a minute, why isn't that something that the European Union is getting? And again, this is somewhere where you see companies constantly caught in the middle. And looking at the elections that are happening around the world, you will always see that this is increasingly coming up as an issue. So Macron has talked about it on his platform a bit. So for us, this is an absolutely is for us, it's a very, very useful first step. It hits two of those sort of theoretical issues. It starts looking at what a framework might look like, and it also started for the first time getting Congress to discuss it. I agree with Greg, it really is only a first step. And I think we also need to acknowledge that at the moment it doesn't exist at all. This was a letter that was given by an Obama administration Attorney General to the previous Congress. So we're at the point that we are now having to, we collectively as stakeholders in the US Congress and the administration are having to start again. I think that's why we have to be conscious that we're at this really, really important in history where the US and stakeholders in the room and academics in the US and around the world can play a key role in trying to help formulate what that policy or what that agreement should look like.
Great. I'll start with a question, I think for Greg and Drew. We heard Suzanne talk about the French system and how significantly different it is in how they allocate authorities. And let's imagine the state of emergency gets fixed, but just the French system before the state of emergency. How would you imagine having the U.S. system interface with a system that lacks probable cause, but instead measures out power of different kind of magistrates and judges in a country like France, which has a long history of rule of law? How can we imagine engaging with countries that are different, but if there's any countries in the world that there ought to be ways to cooperate with, would probably make the list?
So can I take a shot there first? Yeah. I think a good starting point is not just to look at U.S. law, Peter. It's to look at some of the international principles that have been developed about surveillance. And Access and other groups put together these necessary and proportionate principles. And I think they're pretty solid. They're a pretty good place to start. And you can measure laws against those principles. And you can ask yourself, does this law meet the judicial authorization principle or not? And is that principle drawn from good, solid, does it have good, solid backup? So I don't think, again, that we have to import one system and impose it on the world. I think it's more to the point of what is already moving, what is the world already moving toward?
We have the necessary and proportionate principles as they've kind of been termed that articulate things like necessity, proportionality, judicial authorization, as Greg mentioned, that that those principles be maybe integrated more effectively into whatever system we come up with, and those principles honestly drew very heavily from the European system, the European human rights system. So,
hey Drew, where would a person find those principles?
So Greg, you can actually find them necessary and proportionate.org.
Yeah, were you nodding a lot to that? Is that a workable stance for Uganda, Russia, and the rest of your week?
I don't. I think that, and again, there's the reform government surveillance principles as well, which the companies put together after Twitter, which I think are also a very, very valuable set of sort of guidelines for what government surveillance should look like. I don't think that we should be aiming for, and certainly Facebook doesn't think that we should be aiming for a system that fits everyone. This is about raising the bar. This is about making sure that collectively surveillance around the world is meeting a higher human rights standard. So I think that having something that the governments can look to, and I think it's fantastic the work that the Commission is doing on e-evidence, because that isn't just looking at what companies are saying, but it's also looking at what member states should be doing in terms of raising their own standards and processes. It has to be a good thing.
Let me just add one more thing. Look, you could have, take one issue, notice, whether a person who is the subject of a surveillance order ever gets notice. In some systems, there is no notice, and it's provided for by law. I mean, that's the case in the UK. So I would put that down here on the human rights standards. And in other countries, notice is required. And in some countries, notice can be required not simultaneously with an active wiretap, but immediately after a disclosure of stored information. So what do you do when there's that difference, right? You could say, well, let's put everyone where the average is. Not sure how that quite works out with notice. You could say, well, let's use this opportunity to bring people up to the standard in terms of human rights. Or you could say, let's bring everybody down to the standard of no notice because that helps law enforcement. Those are the kinds of decisions we actually have to be making. I know where I come out on a lot of these things. I know where some law enforcement might come out, but I think that nobody's going to get everything that they want out of this process, but we do have to start making some choices.
And just very quickly, extra motivation for meeting a high objective standard in the system is that, as we mentioned, this isn't replacing the MLS system, so it can be something that is only used for a subset, and as far as countries satisfying that standard, they can satisfy it for that subset of requests that involve cross-border data. But also, we're talking about a system where a lot of countries have interest in this data because it's stored abroad or a U.S. company is implicated. So it makes sense that we would want to impose a high objective standard when there are a lot of interests involved to make sure that we're not diminishing the value of the interests of certain countries.
I think I'd like to open it to the floor for questions or comments from anyone here.
I was following the example of notice. We have to be careful here in not looking at elements in isolation. Because if we go for sort of point-to-point symmetry and replication, you have notice of that, need to notice of that. You might have lower standard notice, but that may be compensated by, or very delayed notice, very much after facts, that might be compensated by, for instance, stricter judicial control example, which includes some of those considerations. So it's in a different context when we have to understand that this is something which is currently litigated, so it's different, but what essentially equivalent. We have always taken the position, yes, a nice concept, that this is not about a point-to-point comparison of symmetry, that you have to look at the system in its totality and see if that system delivers a certain level of protection. And that can be done through different tools or means, and even the Court of Justice actually says it, that different means can be used. So that's, I think, something that we should be careful about, taking one element and looking whether that element is present in another system and not considering the
Has the Article 29 Working Party agreed to that as well?
I'm trying to convince them.
Because I think the sense in the United States sometimes has been they have a tick list of everything that's in the European law. And if the United States has other things that are stricter, we don't really pay attention to that. But any place where there's a gap, the United States gets hit. That's at least a perception.
I was joking. I think even the Article 29 has been, actually, when looking at the privacy shield, has taken a lot of responsibility, has been very much forward-looking, the annual review, etc. But the Article 29 this year, actually, in the course of this year, we look at what is called Opinion 12, which is the checklist they have, I don't know, almost in the 90s about what advocacy. And clearly, and the Commission has already expressed this perfectly, we have to issue the communication on the 10th of January, which is called Exchanging and Protecting Personal Data in a Globalized Environment, which says exactly what I've said. That this is not about looking for carbon copy or point that you have to look at the system in its entirety and see whether the system from a functional point of view delivers a certain level of protection.
Let me just follow up on that. The one problem with this holistic look is this look at to see whether the system as a whole meets a standard is that there's no decision maker who can really do that in an objective way, at least in the way that these bilaterals are being set up. The decision maker in the U.S. legislation is the Department of Justice. They could take the holistic look, but it creates this risk that the decision will be made not based on whether human rights factors are met, but on political factors. So I think we need to have some solid comparative factors so that there can be an objective look. Otherwise, it won't be so objective.
On our side, we will do that, and we're not doing this alone. Or it's the Article 29 has to look at the states, and we have to pass through their scrutiny, member states, etc. Of course, there must be, when I'm saying this is not a word, we all recognize that there must be some core, there must be some form of control, some enforceable rights, etc. But I think there's a danger in making this kind of point-to-point. The example, sorry, I don't want to, but the example that was given about France is a very good example. You don't have probable cause in France. And when I was negotiating the umbrella, that's something I heard many times from DOJ. You don't have probable cause in Europe, so what are you complaining about our price? But that type of guarantee, in a certain sense, is ensured differently at another level. There's a sequence of steps. And the fact that you have a magistrate, a judge, looking and ordering certain measures, ensure that in a certain sense, in that type of protection in a different way.
I'm gonna make a short comment, and then we have Hans and then Lonnie. The comment is, Greg, an issue that came up in the Ireland case on standard contracts is that the United States does not have an independent supervisor who can look at the national security practices of the United States government. And so on at least some of the tick lists in Europe, you would need to have an independent authority that could look at the NSA's actions. And the ombudsperson that was created was to have somebody in the State Department who's outside of the intelligence community, but is still part of the Article 2 executive branch, would not qualify as independent under any definition in Europe. But constitutionally, the US government view, and my view as a law professor, is there's no constitutional way to give an independent agency that decision-making authority over a branch of the military and intelligence like the NSA. So if we insisted on having that part of the tick list, there's no way consistent with the US Constitution to do that. So then you say to the US, we'll just go amend the Constitution as a price of getting, an international agreement. And that's asking a lot. So there needs to be some, I think, at least at some level, some pragmatic way of not just having a tick list. We have Hans and then Lonnie.
Do MLAT negotiations create an opportunity to advance the human rights agenda? Instead of thinking of MLATs, human rights as you're defending human rights in the context of MLAT negotiations, can you advance human rights in the context of what's happening in specific?
I think you can, but I think there's also a big risk that you will reduce human rights in this context. And again, it's all going to depend on where it shakes out at the end of the day. I kind of gave a list of things that I thought would bring this arrangement up to an adequate human rights standard. We'll see whether the governments, two of them, are willing to go down that road or not. If they aren't, there's a risk that instead of kind of normalizing at a high human rights standard, you normalize at a low one. And that's the thing that, frankly, I'm trying to avoid.
Are there any characteristics of the MLAT process that make you more or less optimistic of the nature of the players involved in the way negotiations before?
Just keep in mind that one reason the MLAT process works slowly is because there are procedures built in to protect rights. So, for example, when a foreign government right now, under the current system that the U.S. has, wants to get data from a U.S. company, it effectively has to go through DOJ and meet this probable cause standard. So if that standard is not going to be met, what is it that will compensate for it in this agreement? I like the probable cause standard because it creates a requirement that there be a strong factual basis before data is disclosed. And once the data is disclosed, then it's like a choke point in the process, right? Once the data is disclosed, you don't know exactly how it's going to be used in every country to which it will be disclosed. So when it comes to the U.S. legislation, the point of disclosure to be is really a key point to be looking at.
I think you also need to look at so the MLAT process undoubtedly does need to be improved and streamlined. At the moment, it takes between 10 months and a year from the start of an investigator overseas, then submitting something to the US and it ending up with the company and then back again. And if you're trying to investigate most crimes, that's not something that's not a time frame that you want to wait. And there is a secondary issue about a feeling of sovereignty, where a government feels it's investigating a crime in its own country with its own citizens and feels it has the right to get that data, and it just happens that the companies are overseas. So whilst I absolutely agree that it's useful in having that mechanism to do a check, and I don't think there's any suggestion that every country should be using any sort of speeded up process such as the one the UK-US agreement entails. We have to look at what the realistic impact of that is. And the realistic impact for us is being blocked in countries and not being allowed to provide our service, having our people arrested or taken into police stations and questioned. And it's not one that I think at the moment, the way that it's going, or data localization is the other thing where it's going, where we're going to end up with a net gain in human rights if we go down that route. Which is why I think we have to look at what a quicker solution is rather than just fixing the bits of the MLAT system that can be fixed.
Yeah, I mean, it's more a comment, but maybe Greg, you would want to respond. I just want to we'll check and make sure that we're clear conceptually on how the agreement was initially considered. And that has to do with this idea that a person of a particular nationality may want his or her own law to apply to him or her. And so, I mean, just to be really clear, if I understand the way this agreement works, UK applies to a UK person and US law applies to a US person. So in a sense, that is addressing one of the main challenges that we've had, not just with this, but with any sort of framework or mechanism that we've been looking at, which is how can you devise a system that respects the laws of the country and the people who want to be governed by those laws. And it goes back to the point that's exchanged with Bruno Giancarelli and you, Greg, and also Peter, about this idea of looking at the totality. I mean, isn't that just a respect of the individual and separate cultural, historical totality of the circumstances which led to those rules? I mean, even probable cause, it's hard to look at it just by itself. You have to think of, the fact that you acquire the evidence, it's admissible in court, and death penalty can be imposed, or the other kinds of surrounding factors to take a look at the whole big picture. So in a sense, maybe not technically as we were talking about the privacy shield, but conceptually, I mean, do you agree with that characterization? And if you do you disagree that that's on the principle itself, that this is something we want to try to achieve?
I disagree with the characterization. The reason I do is because the UK did not come to the US and say, what we would like to do is to make direct demands of US providers to get data about UK citizens who commit crimes in the UK against UK people. They did not come with that request. They came with the request that they be able to get data on anyone, anywhere, except for Americans in the United States, for a crime over which they assert jurisdiction in the UK. So we're not just looking at the rules for UK people. We're looking at the rules for people worldwide, and the UK is coming to the United States and saying, we want our rules to apply to our investigations, no matter who we're investigating anywhere in the world, except for a person who is an American or who is in the United States. That's what this is about. So I think you really do have to look at it from the perspective of the third country national, because they're the ones who I think we need to protect in this context by putting the human rights standards up here, not where one country or the other would be.
Any other questions for this panel? Yes, please.
You seem like you don't agree.
And I'm just trying to, I'm thinking through the UK law because I can't remember what the exact characterisation of when the UK government when Scheinwald first went and started reviewing this, but I pretty much it was about UK citizens in the UK. And
That's not what the legislation is about.
Yeah, so I know that's not what the US UK-US agreement says. I think that's probably something to be pushing on. But I think we have to be careful about trying to focus on what undoubtedly are the edge cases. Because in UK law, you cannot just go and start surveilling people around the world. There is the Investigation Powers Act and the Regulation Investigation Powers Act before it is 99% about UK citizens or UK people that are in the UK committing crimes in the UK.
So if the UK if the US legislation said this only applies to crimes committed in the UK by UK persons against UK persons, I think we'd have a whole different conversation.
Okay.
All you have to do is know the nationality of everybody in a cybercrime before you do the investigation, and it would work very well. I mean, there's challenges there. So I think we've had a chance for questions, and we're going to get our significant afternoon break now. So we're going to come back in at 25 minutes. There's coffee and snacks in the place where breakfast was earlier today. And let us thank our panel very much.